registry. These cases that are shown on this slide, I don't have time to take you through them, but in short and put simply, they indicate that a land registry title plan does not reveal a legal boundary, and that to identify a legal boundary, it's necessary to ascertain what was intended when the boundary was created. The sort of source document, the conveyance, the transfer, the contract that establish the boundary. If we've got that and it's clear where the legal boundary is, our job is done. The next slide that I want to show you is this one. There are a number of useful resources for dealing with boundaries. Land Registry Practice Guide 40 being a starting point. The textbook Emmett and Ferrand on Title, Chapter 17, again, contains information relating to boundaries. Something you may not be familiar with, the RICS has a boundary procedure for boundary identification, professional standard, which you can look at. And then the Property Protocols website I mentioned contains a boundary dispute protocol. You can also see that on the Property Litigation Association website. And that's a really useful resource that tells you about the problems with boundary identification in the conveyancing process, tells you about the problems associated with what is a legal boundary, and also explains how to deal with boundary disputes. So it's a really useful and free resource that will be helpful for you where there is boundary sensitivity or a boundary or neighbour type of claim or complaint. To avoid problems with regard to boundaries, I think we explain the problems and we set realistic client expectation. They can't rely on title plans. If there is boundary sensitivity, the normal conveyancing process is not going to alleviate the problem or enable us to determine the legal boundary. There are options that are available where we are unable to identify the boundary and there is boundary sensitivity. Last point, a really important practical point. Whenever there's a suggestion from a seller that there's been a boundary dispute or a boundary problem, take a step back and be cautious. I always say to conveyancing clients, I'm in the business of buying property, not buying litigation. So if there's been a boundary dispute in the past or there's been a boundary problem, a boundary's altered or something of that nature, you need to have a deep dig into what was the problem and has it been resolved. You don't want to be buying a property where there's the slightest hint that there's an ongoing boundary dispute or boundary problem. And again, I would even exercise caution where I'm told there's been a problem but it's been resolved. I'd want to satisfy myself that there indeed has been resolution before advising my client to proceed. The next thing I want to talk about, which causes claims, are leasehold transactions. So I'll just put this slide up if I can. Yeah, here we go, hopefully. What causes claims with regard to leasehold transactions? Well, again, doing the simple things wrong or badly causes claims. Not checking the lease, not reading the lease, not make sure that the lease is complete, that the prescribed clauses in the lease itself are not consistent with one another. Lease plans that are inadequate, issues with regard to title. So we need to see the leasehold title that our client is acquiring, and we need to see the superior title out of which the lease is derived. We also need to see management regulations. If there are management companies, have they been established? Have they been properly constituted, etc.? All of these things, all these basic things can cause problems. Leasehold conveyancing generates more claims than freehold conveyancing. Why? Because we're encountering more documents, LPE1s, TA7s, as well as a TA6, service charge accounts, notices with regard to ground rent demands and service charge accounts, details and correspondence relating to disputes between landlord and leaseholder. There's a whole raft of additional documentation that we're likely to encounter and have to deal with. What causes claims? The lease itself. Incomplete, inconsistent, schedules that aren't actually incorporated within the lease, lease plans that are defective, leases that don't contain provision to cover off all the normal things that a lease should provide for, leases that have been defective in the past and haven't been remedied, leases where there's been a deed of variation, but the deed of variation hasn't been registered. All of these sorts of things can cause problems. What rights are granted and reserved? Again, we go back to the principle that I mentioned at the start of my presentation, client objective. My client is buying a fifth or sixth floor apartment, we need to make sure that there are rights that enable our client to access his flat or his apartment. We might also want rights relating to common parts, or the right to use gardens or car parking spaces or garages, etc. Those rights need to be formal rights contained in the lease by way of easement, and those rights should be noted over third-party titles where appropriate. If there are informal rights, it's important that our buyer understands that unless those rights are incorporated into the lease, the rights are personal and are likely to be available by way of license, and therefore the rights are not going to be capable of transmission to our buyer client. Therefore, if the seller is saying, the landlord has allowed me to use a storage cupboard on the ground floor to store my bike, but the lease doesn't make any reference to that agreement, then that would be a license that the landlord could revoke at any time, and certainly isn't automatically to be guaranteed to be transmitted to our buyer client. Our buyer client needs to understand that. So going on a little further, I'll just move the slide again if I can. Other issues that cause claims with regard to leases. Is there a ground rent? Remember, post June 2022, a lease cannot have a monetary ground rent, but before that date it can. So if we're taking an assignment of a lease, there might be a ground rent. If there is a ground rent, is it variable? If it is variable, is there some form of mechanism for increasing the ground rent? Anything that suggests or intimates that the ground rent can double at a frequency of less than 20 years, I would be challenging. Wherever I've got a ground rent review provision in a residential long lease, I would always warn a buyer client that the lease contains a ground rent review provision and that it may be impossible for me to determine what the ground rent will be reviewed to if there is provision that enables a ground rent review or ground rent increase. As far as service charge is concerned, clients need to understand that service charge is a contractual obligation to pay unascertained and unascertainable future expense. The client needs to know that just because we've got 3 years service charge accounts that show the service charge is £1,000 per annum, that is not an indicator that the service charge going forward will be anything like £1,000 per annum. Cost of living increases, the Building Safety Act, if it applies to a property, all of these things can lead to a rocket in the amount of service charge increase. Clients need to understand that. You shouldn't be giving advice on service charge accounts unless you're comfortable in doing so. You do need to explain what services the landlord is obliged to provide within the lease, and you should be checking to make sure the landlord can transmit the cost that it incurs into service charge. But that's really about as far as it goes relating to service charge. If our client wants advice and assistance with regard to service charge or something of that nature, then what you'd be saying to the client is you need an accountant, a forensic accountant advice. If the lease creates the need for a management company, does that company exist? And what's the company's role? Does it own the freehold? Is it subject to a concurrent lease? If it is, what happens if the management company disappears? Do all the rights, duties and obligations then transmit back to the original landlord or building owner? What does the lease say about insurance and what risks are insured against? Again, the lease should be checked to see who's obliged to insure and what are they insuring. Any informal arrangement with regard to insurance should be evidenced by a deed of variation. Clients need to understand what forfeiture clauses are in residential long leases and that they're not sort of archaic and historical sort of remnants, but landlords can and do forfeit leases where leaseholders are in breach of covenant. It's all well and good looking at the repairing obligation on the tenant with regard to the demise. It's also important to see what the landlord is obliged to carry out by way of repair. Because normally in a residential lease, the landlord will be able to transmit the cost that it incurs with regard to repair into the service charge of leaseholders. We also need to make sure that the term of the lease or the remaining term of the lease is sufficient for lending purposes. Always check lender's instructions, and it's well worth checking lender's instructions again before you exchange contracts. With regard to leasehold transactions, watch out for lender claims and lender instructions. Some lenders will regularly change their instructions and you need to be aware of it. The Building Safety Act 2022 will cause problems with regard to leasehold conveyancing. If anyone's doing BSA related work, let me know. I've got loads of information on the Building Safety Act I've written a book for the Law Society on the Building Safety Act. You need to be really careful about the status of the building. Is it a relevant building or a higher risk building? You need to be careful, if it's a relevant building, about the content of landlord and leaseholder deeds of certificate. I would scope the retainer very carefully if I'm acting on a sale of a leasehold flat or an apartment to which the BSA relates. And I'd also be equally careful about scoping the retainer and reporting on title in a residential leasehold purchase of a property to which the BSA relates as well. Caution should be exercised. What I want to do now is just sort of skip along if I can. I want to show you this slide. As I mentioned to you earlier, residential leasehold continues to generate a disproportionate amount of claims, and we need to understand why that is the case. So again, we'll look a little further at the next slide, if we may. We talked about these issues already, the duty of care, the scope of the retainer. We need to make sure when we're doing leasehold work that we're charging an appropriate amount of work fee for the additional amount of work that we're undertaking. We need a complete copy of the lease. Okay, we need to read it from cover to cover. We need to check page numbering, paragraph numbering. Is it all consistent? Is it complete, or are there pages missing? I've dealt with horror stories over the years where the lease has been glaringly incomplete, and therefore the buyer, the residential leaseholder, acquires a lease and hasn't read half the clauses because they're not actually contained within the document. We need to check the superior title out of which the lease is derived. Again, an important point. And if the lease is unregistered, it may be necessary, it's likely to be necessary, it's going to be subject to first registration. Therefore, is the lease going to be capable of first registration? Here in particular, I'm worried about lease plans being Practice Guide 40 compliant. We need to read the lease. Does it make sense? Are there any provisions that are incomplete or vague or ambiguous? If they are, and we're acting for the buyer, we should be indicating them to the seller's solicitors and asking the seller's solicitors to approach the landlord to see if it's possible for the lease to be varied before we proceed to an exchange of contract. This point about reading the lease and making sure it makes sense, it's important that you look at the lease and determine the terms of the lease and that you're happy with them. Other issues that can cause claims. What's been demised? The flat or the apartment, normally, but sometimes not. Balconies can be a problem. They're not, the buyer thinks they're included in part of the demise, but in fact they're defined as being structure. Car parking spaces and garages are commonly omitted with regard to the description of the demise. And the number of times I've dealt with matters where a client's bought a flat and assumed that he's also bought a car parking space or a garage, but the car parking space or garage is not described as being part of the demise. What rights does the tenant have with regard to going on to adjoining property for repair and maintenance? What happens if the tenant or leaseholder wants to improve or alter their property? Can they do so? Can our client gain access and egress from his flat or apartment? Again, I've seen, I kid you not, helicopter leases where the only way a leaseholder could gain access to his lovely penthouse flat is by helicopter, because he has no rights of access and egress over common parts, lifts or stairs, etc. within his lease. What about restrictions? Are there restrictions? Are there covenants being imposed on the leaseholder? And are those restrictions, are those covenants acceptable to the client? Do they impact or impede on client objective, for example? We've already mentioned informal rights. Rights of entry onto adjoining property to carry out repair and maintenance work we haven't talked about. And are there any exceptions and reservations which affect the property? So, for example, if we go back to the Building Safety Act, if a building is a higher risk building, then there are reservations implied into the lease that enable the landlord to inspect the flat or apartment on notice in order to check for Building Safety Act risks. So ground rents, is the ground rent fixed or variable? If it's variable, do we need specialist advice? Who collects the rent? The entity that demands the rent, sends out ground rent demands, is likely to be the landlord. Have we got a receipt for the last payment of ground rent? What are the lender's requirements with regard to ground rent? And any notice to pay ground rent has to be in statutory form, as I mentioned on slide there. What causes claims with regard to service charge? Well, I've touched on this already. What's the service charge regime? What's the estimated service charge account and a final account? And are the two consistent with one another? We need to look at what the seller is saying in the TA7 and what the landlord is saying in the LPE1. Is either aware of anything that could lead to a drastic increase in service charge going forward? And again, if there is indications of such a likely cost, then a client needs to be warned about it. And again, it might be appropriate to advise the surveyor or valuer acting on the client's behalf to assess what we've been told. So whether the landlord is saying the lifts to the property are going to need replacing in the next 3 years, I'd probably want a surveyor or a lift engineer to come out and have a look to say, well, yes, that's right, as opposed to actually, no, that lift is going to need urgent repair in the current service charge year. Management companies, always important to check do they in fact exist. They're sometimes overlooked and don't exist. We need to have a look at its constitution and we need to check that it's been properly run. Are there board meeting minutes? And in those board meeting minutes, are issues being properly discussed with regard to leasehold management? Again, important that we check and we indicate or identify issues for the client. As far as insurance is concerned, what are the insured risks? Who does the lease compel to insure, and has that party in fact insured? And can we see a copy of a policy and policy schedule? Is the policy valid? We're obliged to read the policy to check it covers the risks the lease prescribes. And where a client is concerned about the level of insurance cover, the level of insurance premium, the level of commissions that a landlord is receiving, we should be referring our client to a specialist insurance broker. The client needs to understand in our retainer that our task is simply to check what the lease says with regard to insurance and to make sure that whoever is obliged to insure has complied with their duties under the lease. We mentioned management companies, and the thing here I'm really interested in is what's the management company's obligations and duties? Is that clearly set out? Could be in the form of a concurrent lease, could be in the form of a transfer, could be some form of management regulations. I would always urge caution where a client of mine is asked to become an officer of a management company for two reasons. One, personal liability in the event of insolvency, and two, liability with regard to breaches of the Building Safety Act. I think anyone in their right mind ought to be advised not to be a director or secretary of a management company in connection with blocks of flats. It's a very dangerous potential role or task. What else can cause claims or problems? Fees for assignment or notice of assignment or notice of charge. If the lease says notice of assignment or notice of charge must be given, then that must be complied with. The lease might specify a fee that's paid to the landlord, in which case that fee ought to be paid. It's important that we have evidence that the landlord has acknowledged receipt of the notice of assignment and notice of charge. And so also important that we look at the lease to see what fees are payable, what form the notice must take, and whether or not some form of formal receipt is required. In addition to that, it should normally list the fee that's payable to the landlord for receiving or acknowledging receipt of notice of assignment and notice of charge. Problems that I've seen over the years: leases and counterparts that are not identical, conflicting provisions within the same lease. So landlord obliged to repair balcony, and the balcony is part of the demise, and the leaseholder is obliged to repair the balcony too. Conflicting provisions, as I've mentioned, rights and obligations in schedules, and the schedules aren't incorporated within the lease. Lack of mutually enforceable repairing covenants. So I'm, as a leaseholder, under an obligation to repair in connection with my landlord, but there's nothing in the lease to say I'm under an obligation to repair, and that another leaseholder within the building can bring proceedings against me relating to breach. Deeds of variation. If there is a deed of variation, has it been registered? If there is a deed of variation, why is it being used, and has it in fact varied the defect? Do watch out for defective title insurance in the context of residential long leases. If a lease is defective, then you can't take out a defective title insurance policy because the lease is a contractual document. You can take out defective title insurance with regard to leasehold titles or superior titles out of which the lease is derived. And do watch to make sure that the main body of the lease is always consistent with the prescribed clauses within the lease. Remember, prescribed clauses required in connection with leases that I think were granted after 2008. The next thing I want to talk about, because I have to, is the dreaded Building Safety Act. And as I mentioned to you earlier, the Building Safety Act is a problem area for residential leasehold conveyancers. In the Building Safety Act, put very simply, there are two types of building that cause concern. Relevant buildings, buildings that exceed 5 stories in height or more than 11 meters in height, containing 2 residential units, in which case it would be necessary for a seller of such a flat or an apartment within a building to produce a leaseholder deed of certificate to the buyer. And it would also be necessary for a landlord, the seller to serve notice of an intention to sell on the landlord, and for the landlord to issue a landlord certificate. A landlord certificate gives information about the landlord's status as at the 14th of February 2022, and also confirms the landlord's knowledge with regard to state of disrepair concerning building safety defects. A seller should normally have a landlord certificate provided to them by the landlord, and the seller should produce a leaseholder deed of certificate, which should be made available to the buyer. It's not necessary for a leaseholder deed of certificate to be served on the landlord unless the landlord requests it. As far as the landlord certificate is concerned, the seller should always make that available to the buyer. And if you're acting for a buyer in connection with a leasehold transaction to which the BSA relates, the safe course is to tell the client that we won't be giving advice on the content of a landlord certificate. A leaseholder deed of certificate is normally produced in the conveyancing process by the seller leaseholder, and what this does is state whether or not the lease that the leaseholder is selling is a qualifying lease or a non-qualifying lease. If it is a qualifying lease, then the protection of Schedule 8 of the Building Safety Act applies, which, put simply, limits what a landlord can recover from that leaseholder with regard to remediation costs for fire safety or building safety defects. So it's always worth looking at the status of a building and identifying if it's a relevant building. If it's a relevant building and you're acting for a buyer, you're likely to encounter a landlord certificate and a leaseholder deed of certificate. In an ideal world, you've got a scenario where the leaseholder deed of certificate is produced to your client, but the landlord hasn't seen it. And in an ideal world where the seller has notified the landlord of their intention to sell, the landlord has failed within the 4-week period prescribed by the Act to produce a landlord certificate. In those circumstances, yet again, the buyer is in a better position if the landlord has not served a landlord certificate on the seller. Again, that failure would mean that the landlord is less likely to be able to recover remediation costs for relevant defects within service charge as against that tenant. On slide, I talk about higher risk buildings. A relevant building, there's no central register for. It's down to you, if you're acting for a buyer, to ask interested parties if anyone knows the status of the building. Is it a relevant building or not? With regard to higher risk buildings, that sort of dilemma is removed from us because higher risk buildings have to be registered with the building safety regulator. The register is in fact maintained by the Health and Safety Executive. You go on the HSE website, you look at the higher risk buildings register, you put in a postcode, and that register will tell you if the building that your client is interested in, or the flat or the apartment, is within. The register will tell you if the building is registered as a higher risk building. If it is registered as a higher risk building, there are 2 important consequences. Important consequence number 1, courtesy of amendment to Section 30 of the Landlord and Tenant Act 1985, the position is that there are terms implied into residential long leases. And the second thing, if a building is registered as a higher risk building, the likelihood is there will be an increase in costs with regard to service charge because the landlord is obliged, if a building is a higher risk building, to undertake a lot more building safety management issues and is entitled to transmit the cost relating to those issues into the service charge of leaseholders. So, before we finish, we'll start having a look to see if there's any questions. Hopefully, you've understood everything I've said today. If there is a need to revisit any of the topics, then the webinar has been recorded. And what I'm going to do now, if I may, Barty, is open up the webinar to see if anyone has any questions or queries. So I'm going to have a look at the chat. If anyone has any burning questions or queries, could you put them in the chat for me? Let's see if we can open up the chat. Does anyone have any questions? The other alternative is we can put your microphones on, and you can raise a question by sort of talking to me directly. Barty, I can't seem to see the chat.
There is a chat there.
Yeah, are there any questions?
No, there are no questions. I mean, this is open to
Absolutely.
the attendees. They can ask the question now
absolutely.
if they wanted.
If you're too shy to raise any questions, my email address is shown on slide. Barty, if I do get any emails with questions, I'll share them with you so that you can share them to attendees.
Yes. All
That
right.
would be great. Okay.
We can. I mean, we'll be sending the recording to
Lovely. Thank you.
who've been registered. Quite a few have registered, so we'll be sending this recording to them.
Lovely. So if anyone has a question, fire away in the chat now. I hope that's been of use to you. A few things that I think before we finish. One, if you're not aware of this, Howden insurance brokers send out twice a year, for anyone that's interested, details about claims against solicitors. And in that, there's a section on claims against conveyancers, and that's really interesting. The second thing that I want you to be aware of is this point about just making sure you do the simple things well. You know, a lot of negligence claims arise from silly errors. And the reason there are silly errors is because we're so busy. So, you know, take time out to have a look at a matter. You know, if something doesn't look right or there's something that you're not sure about, take a step back. Ask a colleague perhaps to have a look at the file. But where I see problems is where someone thinks, oh, I don't have time, it'll be all right, I'll just proceed. Or, you know, if there was an issue, someone would have dealt with it, or the seller solicitors would have told me about it. Therefore, there isn't a problem. Therefore, I'm happy to proceed. Okay, right. So, Victoria,
thank you so much. I mean, I'd like to thank you, Ian.
No problem, Barty. My pleasure.
I mean, this has been good for us. So where we are in the conveyancing process, where the search agents come in.
Yes.
So when we have a really urgent search, we realize they've forgotten to put the searches.
Yes.
They're so busy looking. So this has been really good for us to understand.
That's fine. That's fine. Lovely. Okay.
Why everything is urgent now.
Yes, it is, isn't it? Yes, yeah. I'll just put this on slide. Property Law UK is our subscription service. If anyone's interested, drop me a note and we can offer you a discount if you're a client of Barty's.
Yes, absolutely.
Yeah, thank you very much. Thank you, Barty.
Thank you, Ian. Thank you so much.
Take care. No problem at all. Thanks, everyone. And cheers, Graham. Thanks, everyone.